crashes, defective products, dangerous drugs, injuries, and abuse. Across the state of Alabama, the attorneys, proudly sponsored by the law firm of Hollis, Wright, are here to serve you. Your tough legal questions answered by our experts with host David Lamb and the attorneys of Hollis, Wright.
Good evening and welcome into The Attorneys. Thank you for joining us tonight. Our topic of conversation is something that we believe will be of interest to you. So for the next half hour, we're going to break it down, have a panel of experts to help us do that. A couple of reminders before we jump into tonight's conversation. We'd love you to take advantage of the opportunity to speak with attorneys from Hollis, Wright, who are standing by live all throughout the program. That free, confidential, and off-air conversation is yours when you pick up the phone and give them a call at 844-529-8255, or locally the number is 205-324-3600. Other ways for you to communicate with the law firm at the bottom of the screen all throughout the program, so we really try to make it easy for you to get some awesome free legal advice. Leading our conversation tonight, he's the managing partner of Hollis, Wright. Good to see you, Josh Wright.
Good to see you, my friend. How you doing?
I'm doing well, thank you, sir.
Good. You know, and there are people actually on the other end of those lines, right? So if you call, text, email, if you hit us up on Facebook or Twitter, you're going to have a free, confidential ability to communicate with a lawyer about an issue that may be impacting your life. That's one of the unique issues in our show, that we're not going to necessarily put you on the air live where people have to hear what your legal issue is. Instead, we're happy to work with you behind the scenes as a lawyer and a client relationship needs to be able to answer those questions. And you know, a lot of times, David, we may not be able to answer the question. I mean, there are a lot of topics that we do on this show that we have no knowledge of. However, one thing we do have is a network of lawyers that we can get you to be able to answer questions for you that could face you in your life. And so I hope people will take advantage of it. And I think for the last 8 years, people have been taking advantage of it. But providing free legal advice is an outreach option for our law firm. We really like it.
A lot of folks take advantage
Speaking of outreach, we got our good friend Drew McNutt here with us today. He's one of our guys that comes on the show a lot, one of our lawyers at our firm, incredible litigator. I've been so impressed with him over the years. And we're doing a show on just kind of accident injury related issues, not just car related issues, but accident injury generally. And this is kind of the specialty of what Drew does. Drew, a lot of times, I don't want to speak for you, but a lot of times a client will come in and say, hey, here's my issue. You know, I have this work-related issue, or I have this product problem where I was injured by a product, or I have some other issue going on in my life that I need help with. And Drew is able to evaluate it based on the law and the legality and the facts and determine whether or not someone's got a case. And so there's nobody better at our firm to come on to answer these questions. Good to see you once again.
Thanks for having me.
I get to see you every day, but it's good to have you on the show. All right, talk to us just a little bit about your practice. It's pretty diverse. You're not just handling car wrecks. You handle a lot of personal injury related stuff.
So I think a lot of people, they see a lot of advertising about car accidents and those things, but there are a lot of other claims that people can bring. I mean, just off the top of my head, things that come to mind are premises liability claims. They can be difficult, but there are a lot of premise liability issues. And then some claims people don't really know about. You know, you're injured in an automobile accident with a drunk driver. He's not the only person, he or she is not the only person you could potentially go after. There's liquor liability, dram shop litigation that can be involved in those cases. Any sort of industrial incident or construction incident, the first thought is, hey, it's a work comp claim. But there are also co-employee, third-party claims, other people that may be liable, sort of downstream or upstream from where you are. And so then you have, your med mals and your product liability claims.
How do you keep abreast? I mean, you just named a bunch of topics that I know you handle and I handle too. How do you personally keep abreast of the law changes? Because the law changes, the statutes change. Kind of explain that process, because I think there are a lot of questions we get about how do you know so much about different topics? Yeah. How do you keep abreast of that stuff?
One is handling the cases. I mean, I think if you're not going to have every case every day, but if you get enough of them over the years, you sort of, it's every time you get a new one, it's a refresher. There's also, jury verdict reporters that come out about cases that are getting tried. And then, every week, if the Alabama Supreme Court's releasing opinions, they get published. And if it's something in our wheelhouse, we'll take a look at it, make sure we know what the law is. And usually that'll trigger you to be like, you may not know exactly what the case says, but you know there's a case out there that dealt with it, and from there you can sort of go down the rabbit hole and find it.
You know, David, it's one of the other ways we do it is we collaborate together as a law firm. You know, we now have 11 lawyers. It's amazing that we started this firm with 2 lawyers and 1 secretary, and we've slowly but surely grown. And
how long ago?
We started about, let's see, 19 years ago.
Oh, wow.
So it's been, we're getting close to 20 years. But, you know, we have grown a good sustained growth. We don't just add lawyers for the sake of adding lawyers. We add them based on the business that is coming in to be able to help people in the community. And, you know, we collaborate a lot. I mean, I can think recently of an email I just received related to a change in the law where Drew had a response to that email and said, hey, we ought to consider, you know, coming up with this information that we can all use for the benefit of our clients. So a lot of times collaboration in a law firm with multiple lawyers is also a great component to keep abreast of changes in the law. And these laws do change, whether it's a premises liability slip and fall case or a dog bite case or a product liability case. The law, either the statute or maybe opinions from the Alabama Supreme Court or from the federal courts, can impact whether you can be successful in a case and how to evaluate those cases. Yeah.
Question we've got here, love getting your questions, so keep them coming. The question is, if I'm involved in a motor vehicle accident, are there certain things I should do at the scene and after leaving the accident scene?
I mean, obviously at the scene, I think the first thing you do is make sure everybody's okay, call the authorities, make sure a police report is filled out. You know, we'll have people call us periodically and be like, well, we just talked and nobody filled out a police report. I went to the ER by my own vehicle. It's important to get a police report, to get it documented, to get everybody's information. But really at the scene, if somebody's injured, make sure they're getting medical attention, make sure the police are called, and then from there, once it's sort of calmed down, you can sort of look at different things, whether it's photographs of the vehicles, things like that. But generally at the scene, it's pretty much get the authorities there, get people checked out if they need to be.
We're getting ready to go to break, and one of the things I want to talk about when we come back, and I'm going to get Drew to explain, is you have the ability with lawyers on our side of the bar to have a contract that's a contingency fee contract where you're not going to have to pay out of pocket, and you get the same quality of legal service as you would on the defense side of the bar. And so I want to talk about that. I'm going to ask Drew some questions about that to explain how that process works. So if you're sitting on your couch right now and you've had an issue and you want someone to evaluate it, but you don't think you can afford a lawyer, we're going to explain to you how you can afford a lawyer.
All right. We're stepping aside right here. Our first break of the evening. As we do so, don't forget ways you can join our conversation. Would love to have you do so. Stay tuned. More of the attorneys coming right up.
I'm Josh Wright with the law firm of Hollis, Wright, a personal injury law firm. Thank you for watching The Attorneys. Now, we hope you, a friend, or a loved one never needs legal counsel for a case. But if you do, the goal of the show is simple. Provide answers and legal counsel when you need it the most. Your call to the show is free, so if you have questions specific to the show or related to other accident or injury-related topics, you can call, email, or text us. Or you can also follow us on Facebook or Twitter, or simply contact us by going to hollis-wright.com and click on the Contact Us link. We know your time is valuable, so thank you for spending it with us watching The Attorneys. It's common for a potential client to ask, there are many great firms out there. What separates Hollis Wright from other law firms? My response is generally to talk about the strengths of our law firm in handling cases throughout Alabama and the United States. That we've recovered through verdicts and settlements, hundreds of millions of dollars for our clients. That we have financial resources to hire any required expert and to take their case all the way to trial, even if it costs us hundreds of thousands of dollars to do so. That we settle cases for top dollar before trial is needed because the insurance companies and defendants know we have the ability to take a case all the way to trial. That we handle cases only on a contingency fee, which means we never ask the client to pay any costs of litigation whatsoever and only recover those costs in a fee if we win for the client. That we have a staff of more than 20 employees that help us litigate cases from start to finish. That we've had a television show on NBC 13 for 6 years that answers thousands of questions to citizens for free each year. But what I've learned in the last 20 years as a trial lawyer is that clients want more and deserve more than all those things. Those things are expected of each law firm they consider. So with that wisdom, what I tell clients now is simply this. We are a family-oriented practice at Hollis Wright, just like their own family. That we are a team-oriented group that engages in team-building exercises and team-building events because it helps our clients win cases. That we are dads and moms and brothers and sisters. That we are former Alabama trial lawyer presidents. That we return every single telephone call from every single client. That our bedside manner is second to none. So what really separates our firm from others? We're balanced and well-rounded, and as such, we relate to people not just as lawyers, but as compassionate human beings. Human beings that know what it's like to face a day in court. We are advocates, we are compassionate, we are tireless. We are, simply put, Hollis Wright.
Welcome back in to the attorneys. Thanks for joining us tonight. Hey, a couple of reminders before we get back into this conversation. Don't forget, attorneys from Hollis Wright standing by live to speak to those attorneys. All you got to do is give them a call, 844-529-8255, or you can do so locally, the number 205-324-3600. Remember, that conversation with attorneys from Hollis Wright, they're really there, and they'll speak with you. That's an all-fair, confidential conversation you can have with them. Josh?
All right, so when we went to break, Drew, I had talked about this concept of a contingency fee arrangement, and we throw that term around a lot. But in order to make sure people understand how the process works, explain, if you will, how do you retain somebody if you've had a personal injury where you don't have to come out of pocket?
Okay, so obviously all of our cases are handled on what's called a contingency fee, and it basically means that you're able to get good quality, competent legal services up front without having to come out of pocket as the client. I mean, if it's a company or an insurance company, they're going to pay their lawyers by the hour, and they're going to pay them good money by the hour to investigate, prosecute, and defend their cases. Everyday people that are injured, one, either can't afford that hourly rate, or two, they don't want to come out of pocket, given sometimes the uncertainty involved in litigation. And so a contingency fee allows them on the front end to get quality legal services without having to come out of pocket. And then if there is a recovery, the lawyer would get a percentage of that recovery.
And that, that's just one way that we allow as a group of lawyers an opportunity for people to come to us, not have to come out of pocket financially, and get a really high level legal service. In addition, we're going to front the expenses on expert witnesses and all the things necessary in order to prosecute your case correctly. So, one of the things you need to ask when you're trying to assess whether or not you're going to hire one lawyer, one law firm over another law firm, is do they have the ability and the resources to take a case to trial? And that's an important component to this whole thing.
A question we've got here, if I'm injured and want to pursue a claim, how long do I have to file the lawsuit?
It's always, it's a hard answer to say that it depends, but generally speaking, it's going to be 2 years. There are some caveats to that depending on factual situations, but generally speaking, you've got 2 years from the date of the incident, not the date of the injury, to file a lawsuit.
Okay.
There are a couple exceptions. Let's talk about those.
Yeah.
When you're dealing with municipalities or counties, sometimes that amount of time, maybe not the statute, but the notice of claim requirements may restrict the time within which you can present a claim.
So historically, counties and municipalities have been immune from lawsuits. There are some carve-outs to that. But if you are going to pursue that claim against a municipality, you have to file what's called a notice of claim with the city within 6 months. And if you don't do that, you can't file a lawsuit within your 2 years. With a county, it's a year. There's some technical requirements of what has to go into there by statute. But yeah, you're exactly right. And sometimes it can be shorter depending on whether it's a federal entity and some other things. But for municipalities and counties in Alabama, it's 6 months and a year.
And as we're talking about the shortness, let's also talk about some cases in certain sectors of the personal injury world, there are rapid response teams that are on the ground that require you as a plaintiff and a victim to get a lawyer right away.
This sort of dovetails with what we were talking about the contingency fee and why it's beneficial to injured victims. The companies that oftentimes we're suing are large corporations that operate throughout the United States, and the firms that represent them will have what are called rapid response team. If there's an incident at a industrial site, or if there's a tractor trailer accident, they will often have experts and lawyers on the ground within hours of the incident, starting an investigation, getting witness statements, getting experts there to evaluate what happened, and sort of shaping the case to try to build a defense. And it's important, if you're involved in one of those incidents, to get a lawyer quickly so that you can have somebody on your side doing the same thing.
How do you handle distracted circumstances in driving, for example, like in the questions you ask in discovery, in the written questions we exchange back and forth? How do you handle that now? Because that's become so much more prevalent, for example, in car accidents and trucking cases and those types of things.
Yeah, I think everybody would agree. You can't go down the road and stop at a red light or be driving down 280 and not see somebody on their cell phone while they're driving. And it's becoming a significant issue. It's illegal, but people continue to do it. And so on the front end, it's about preservation. It's about making sure that the person that caused the incident, if you think they've been texting or driving or surfing the internet on their phone, it's about making sure they preserve the data on their cell phone. And then on the back end, once you file your lawsuit, you have to send out subpoenas to the various cell phone providers. And from there, you may have to get an expert in to do a download. I mean, basically, we're calling them phones, but they're really computers in our pockets. And it has so much information that if you get there and you think that's an issue, you can have somebody come in and forensically download and see exactly what that phone was doing in the seconds and minutes leading up to the collision.
And that can become a critical component to, really what caused that accident, who is responsible for an injury. And we see that a lot, and experts have become a lot more prevalent, as Drew mentioned. These forensic downloads are super important in cases. There's a unique and interesting tool that lawyers can use too that shifts burdens if people don't do the right thing. And I'll give you a good example. If there's a car accident that we think there's a distracted component to it, we send a letter to the insurance company and or the driver of that vehicle to preserve that cell phone. If for some reason that cell phone comes up missing, or lost or broken, or because they want to not preserve that information because they know it's damaging, we have the ability to argue that they spoliated or they prevented us from having access to that information and potentially shift a burden against them for them to disprove that they weren't distracted driving. I know that's a little complicated, but the point is that if the lawyer gets involved early enough, we have the ability to maybe even shift the burden if for some reason a distracted driver tries to lose their cell phone in such a way that the distracted driver is at a real disadvantage legally. So there are reasons why you get lawyers involved and get them involved quickly.
Absolutely. All right, time for us to take our final break of the evening. As we do that, a reminder, lawyers from Hollis Wright standing by live right now to speak with you, 844-529-8255, or locally, 205-324-3600. Stay tuned. The final segment of The Attorneys coming right up. Stay with us.
I'm attorney John Spade with the Hollis Wright Law Firm. If you have ever had a personal injury claim, the attorney handling your case has likely told you that a portion of your settlement would have to be used to pay back your health insurance company for the medical bills that they paid relating to your injuries. This is called subrogation. In this week's Legal 411, we are answering the question, what is subrogation and how does it affect your personal injury claim? When you purchase health insurance, you sign a contract with the health insurance company, which provides that in exchange for you paying a monthly premium, the insurance company will pay your medical bills when you're injured. Now, that contract has a paragraph that gives your health insurance company the right to seek repayment for the medical bills they paid if you in turn use those medical bills as a basis to recover from a third party that caused your injury. The idea is that your health insurance company would not have had to pay your medical bills if it weren't for the wrongdoing of the third party. Now, health insurance companies routinely put attorneys on notice of their subrogation claims by outlining exactly which medical payments the health insurance company is claiming a subrogation claim for and for what amounts. Throughout the handling of your case, your attorney should be aware of the amount of subrogation your health insurance company is claiming and whether all the claimed subrogation is related to your underlying personal injury case. That way, if your case resolves, your attorney can then negotiate a reduction of the health insurance company's subrogation claim. Subrogation is one of the many moving parts that can affect your personal injury settlement and what you stand to recover. Please remember, your call, email, or text to the attorneys is free. All of us at Hollis Wright want to help answer your questions on real issues you face. Remember, a competent lawyer will respond to every question you send in. That's our pledge and our promise to you. Thanks for watching The Attorneys on WBTM 13.
Welcome back into The Attorneys, our final segment, just about 7 minutes remaining. So if you want to take advantage of that opportunity to speak with the attorneys of Hollis Wright, pick up the phone and give them a call. About 7 minutes remaining for you to do so. Josh?
Drew, one of the things that causes a lot of confusion and frustration for clients is subrogation. And I don't want to we could do an entire show on this, and we've done many shows on this. I don't want to get too into the weeds on it, but we do a pretty good job at our law firm of advising clients on the front end what subrogation is. Can you talk generally, just give a simple example of how it works so the viewing audience understands how they could conceivably be required if they're the victim to pay their own insurance back?
Okay. So I don't know that I've ever seen a health insurance contract that didn't have a subrogation provision in it. And basically, there's a contractual provision in your agreement with either Blue Cross or whoever it is that if you're injured and you then seek a recovery from a third party and you recover, that they're entitled to get the amount of money they paid for the medical treatment related to that injury back. Basically, if you're going to claim medical bills and get a third party's insurance company to pay you for those medical bills because it was the third party's fault, then your insurance company wants to get their money back. Same thing with Medicare and Medicaid, and it's a statutory provision. Basically, there's a law that says if you recover from somebody, we get our money back. Now, as lawyers, clients are oftentimes, well, why am I paying a premium? Well, the sort of underlying justification for it is they don't want somebody to get a double recovery. You don't get to claim the bills and then not have actually had to pay them. And so basically that's where it is. Ultimately, your lawyer, if you're able to get a recovery, can negotiate with your health provider, with Medicare, with Medicaid, to get that ultimate reimbursement figure reduced, which maximizes what goes in the client's pocket.
And one of the things that generally will resonate with my clients when they're frustrated about the fact that a portion of their settlement may have to be paid back is two things. Drew just hit on one of them, which is that if you get to the right law firm, they have relationships with these subrogation holders like Blue Cross Blue Shield of Alabama, like Alliant Health, like Medicare, Medicaid, where they have the ability to negotiate down what you actually have to pay to a smaller number that's more palatable, if you will. The second thing is an explanation of why, for example, in Drew's example he used, why, for example, Blue Cross would be able to get reimbursement. And it's because Blue Cross, if you look at it from their shoes, they had to pay for something that's not their fault either. And it wasn't the victim's fault, but they were responsible for coming out of pocket. And when they came out of pocket to protect and do what was right per their contract with their insured, they ought to get reimbursed for it too. And a lot of times people will sit back and they may be frustrated with it and say, okay, hold on, that makes a little more sense because of the fact that they didn't do anything wrong either, and now they're being responsible for paying it, and they're doing it because they have a contract with you. Mm-hmm. It's a complicated area of the law, and we have done shows on this. We don't do a lot of them, but just know this. You want to get to a law firm that if you have bills to pay back, the lawyer can negotiate those down for you so you don't have to pay a lot back.
Mm-hmm. Real quickly, about 4 minutes remaining, we want to get to this question here. I was recently in an accident where I was injured on someone else's property. I've learned that the other people were injured before me due to the same condition. Will this help my case, and if so, how?
Yes, it will. Premises cases are very unique, and they can be very challenging in Alabama. I mean, ultimately, the premise owner is not an insurer of any and all injuries. And I think the case law repeats that over and over again. Just because you're injured on somebody's property doesn't mean they have to compensate you. What you have to do is you have to prove that there was a dangerous condition, that the homeowner or the business owner or the premises owner knew or should have known of that condition, and they failed to remedy it or they failed to warn of it. And so with prior incidents like that, what it allows you to do is use those to prove notice, to prove that they knew or should have known and that they should have done something about it, whether it's warning or fixing it.
Yeah, there are circumstances where, as a lawyer, you can use previous accidents, previous bad driving, previous issues where a company was on notice to the advantage of your case and maybe even warrant punitive damages, which are damages that are in addition to what makes you whole, lost wages, medical bill reimbursement, future medical bills, those types of things. Punitive damages are in addition to that, and sometimes notice, knowledge, and previous conduct can help you get an additional component of damage, and that's also important not just if you try your case, because a lot of cases don't try, they settle. But if you settle your case, because it is a hammer, if you will, that we can use against the insurance companies to establish how much that the defendant's going to have to pay because of punitive damages, and use that to increase the value of your case from a settlement perspective. So it's super important.
Just about out of time, less than 2 minutes remaining in the show, but want to give both of you the opportunity for a final thought. And Drew, if you would, you go first. I
think sort of my final thought today would be, some of these are self-explanatory, some of these personal injury cases. Rear-ended by a motor vehicle, you fall on somebody's property as a result of a defective condition. You know those, but there are claims that can be made that not everybody's aware of, and it's important for you to contact a lawyer because people may try to resolve their motor vehicle claim not knowing that there's a dram shop component or not knowing that there's a negligent hiring, training, supervision claim to be made. They may settle their work comp case and not know that there's a potential third-party case. And so if you've been seriously injured in an incident, whether it's on the job, in a motor vehicle collision, on somebody's property, contact a lawyer and ask them to evaluate what other claims can be made other than the obvious ones.
Yeah, the one thing I would say is this. We get this a lot. I'm not litigious. I don't like to have to file a lawsuit, and I respect that. I do 100%. And I understand certain people are raised in environments where they don't want to pursue a claim. But a couple things. One, a lot of claims don't go to trial, right? They're resolved with insurance companies. And there's a reason why people have insurance. They have insurance to insure and maintain. They're protected if they make a mistake. So if you weren't injured at any fault of your own, don't be afraid to at least consult with a lawyer to determine whether or not there's a viable cause of action that could be used to compensate you for the wrongful conduct of another person that caused the accident. Just, be willing to go talk with a lawyer.
Appreciate it.
Great job, Drew.
Thanks.
Nice job. Appreciate you guys being with us, and you all as well. Thanks so much for the time as we wrap things up. Here's how you can get in touch with the firm. That information is still available. Just search Hollis Wright and find it there. Thanks so much. We'll see you next time here on The Attorneys.
Thanks for watching The Attorneys, sponsored by Hollis Wright.